Good afternoon, all. Welcome to the third day of the internship. I'm also enjoying with you and I'm also learning with you. So I'm very happy that you come up with some questions and where I have to apply my mind and answer. And see, lawyer's job is not just to go to court and submit your case. It is much more than that. And there is one thing which I will discuss today in today's session, that is of the public interest litigation. So, what is public interest litigation? Is something where you are going to lay down the law of this country. See, it is highly impossible to have all the laws in place. See, WhatsApp came later on, or some digital media came later on. There were not so many TV news channels. So Evidence Act, Criminal Procedure Code, and Indian Penal Code, all these laws are very exhaustive. Still, there may be something which is not covered by these acts. So there are laws which will be evolving on as the time goes. So public interest litigation is one such tool by with the help of which we can, if there is some injustice in the life of somebody, or there is a injustice is done by some department, by some people, by any association, then this public interest litigation is a tool through which you can approach the court. And for that, remember one thing: you may not be lawyer, you may not have any locus standi. And now, what is the meaning of locus standi? That is without any capacity. Even if you are not affected by it, but your country is affected, the social surrounding is affected, the society is affected, you can take this tool of public interest litigation and go to the court and request the court they lay down the law on this, because there is no law on this, and because of this there is an injustice into so many people. Now here I will give one or two examples, that is of RTI Act. Everybody know how powerful the RTI Act is, but who brought it? Let me tell you. First, it came through the court, and then the parliament laid down the law. So RTI Act, there is also some improvements later on, and there are some judgments also pending. There is a court proceeding going on, but still there is every day there is improvement. Now RTI is such a powerful tool. With the help of that, you can find out what is going in the government. So yes, it is misuse also, but let me tell you, because of the such RTIs and such other public related laws, which are in the domain of the country, it has helped their country to become a better country day by day. Now, let me give you one example of Bhauri Devi case. Now, everybody knows, now we have laws that at sexual harassment case at workplace, if somebody harasses you, you can always file a case, because now there is a sexual harassment workplace case law is laid down. But before that, when Bhauri Devi was raped, now who was Bhauri Devi? If somebody doesn't know, let me take you to the Rajasthan. In Rajasthan, Bhauri Devi was a Sathin. Sathin is called a person who goes and जैसे महाराष्ट्र में आंगनवाड़ी सेविका है, there it was Satin who used to do government jobs and सब help some children to make them, feed them something if they are poor, to teach them basic studies. Now she was on a government job, and it was word used for her was Satin. And because she was a lady with lot of courage, she tried to stop one child marriage in the Rajasthan. When she tried to stop, because she was from a lower caste, or the people who were from higher caste, these 4 or 5 people raped her, and nobody was ready to take her FIR. In fact, they were telling the higher caste people will not rape a lady who is from the lower caste ever. This was the situation in the there in the Rajasthan. Somehow Bhavari Devi's case was reported in some newspaper. Through that newspaper, then lot of pressures come. All the NGOs, mostly the ladies NGOs, got together all over the country, and they started agitating. Then police has to lodge an FIR. Then also beginning they were not ready to arrest, but somehow this matter went up to Supreme Court. Now when this matter went to Supreme Court, there is a Vishaka guidelines adopted by our country before this sexual harassment at workplace. This law came. Now, when this before this law came, the Vishaka was a group of ladies who were NGOs, and they what they did do, they filed an writ petition in the Supreme Court, which was converted to PIL, and there were many writ petitions. And Vishaka was the first in the cause list, that is the कोर्ट का एक बोर्ड होता है जिसपे उसका फर्स्ट नाम था, तो विशाखा, so it is known as Vishaka case or Bhavri Davis case. And Vishaka guidelines, it was then court said that it should be monitored, that Bhavri Davis, whoever has raped her, has to be arrested and they have to be punished as per the law. The trial has to go on. And because of this judgment, the court said, now whoever works in the government department, if the work, it is at workplace, and also a public limited company or any private limited company where more than 20 people are working. Now, though there is a complete committee and everything, before it was not there. They have to form a small committee of the ladies, where one will be man, two will be women, or mostly that was a situation a few years back. And these will look after any complaint by any ladies who is working at a workplace. Now, for workplace, the first time this law came in the form of Vishaka guidelines. So, see, it was not laid down by Parliament. Who create the law? The Parliament. It is, see, judiciary is to implement the law, and the Parliament is to create the law. See, the Parliament did not create the law, but Supreme Court came to aid of the common people, the local people or the citizens of India through this public interest litigation. So I would always request that public interest litigation is a tool through which you can always go to the court that, and you can say this is what is in public interest. So it is always for social cause, and your object should be very clear. You should go with the clean hands. You cannot go for your own self for public. I cannot go, so I am not unable to breathe here in this society. For my society, I can't go. I have to go for all the people around me, for the common public code. For my personal problem, I can't go and file a public interest litigation because it is called public interest litigation. Nowadays, people are filing left and right to public interest litigation, but the real reason for filing public interest litigation, that it should be for social cause and it should be with clean hand. That is, आपका कुछ interest नहीं होना चाहिए. You should not have any interest in that, your personal interest. Secondly, it should be with clean mind and clean heart, and also in one judgment said it should be a clean object also. Your object should be very clean. You want to change something in the country for betterment of the people of the country. Then Vishaka guidelines are, it governed the whole of the country till law was laid down finally in 2013 for sexual harassment workplace. Parliament came out with the law. So this is public interest litigation. If you read this, you will find out that Vishaka guidelines, I will ask Vishnu or Vandana to later on put Bhavri Devi's case in our chat box. So you all will know. Now, second part we will go for today is very important part for any lawyers, and that is drafting. How do we draft? As a lawyer, you may get any case. See, tomorrow you may be second year, third year, fourth year student. If you are 5 years course or 3 years course, third year, you are going to become a lawyer. Now, who will give you the briefs? Who will give you the paper book? How, if there is some PIL comes to you, how you will draft? And everything format is not available with you. I'm coming with a drafting book which will have few of the formats, but every time you cannot have a format. Every case will be different. How you will draft? Suppose a divorce petition comes, suppose a maintenance case comes. So where you are going? And there are people who may not give their personal cases. If you ask me, if I have to give you ever my case, my client's information may go to you. So I will be little skeptical of not sharing my files with you. In such kind of cases, what you will do? Books may not offer you completely. There is a method which I have developed myself for drafting. That is first thing. See, if a client comes to you, it is about maintenance case or it is about divorce petition. Now, simple thing. If you are staying in Maharashtra and a divorce case comes to you, The simple thing, you go to any indiankanun.com or any or you go to library and get a book on the subject related. Start reading it, and there are some judgments. Note down the important judgments. See, it is about the cruelty by the husband to the wife. Now, husband has caused a cruelty, that's why she wants to take divorce. In such kind of matters, you have to read Hindu Marriage Act if it is a Hindu matter. If it is a Parsi law, you have Parsi book. So, one easy thing is you get a book from library. If library books are not available, go to, if you are staying in Maharashtra, go to Bombay High Court website. There are judgments. Try to read it and read the subject related and note down some points. You will find out sections also. You will find out the prayers also. See, when the matter goes to High Court, you will find out the prayers also. In Delhi High Court, we also find the Delhi District Court matters also on the online. I've got a Jammu and Kashmir one small order here today, which we will be reading during the session. That is lower courts. So in Maharashtra, in some of the session court, they are uploading their law orders. So you read those orders and you read those judgments. From there, you will know how to draft. And the basic criteria, title and prayer is simple. There is no format. If you ask for public interest litigation, there is no format. For writ petition, there is no format. For civil suit, there is a format. For but it is also not just left and right. This is the way it should be done. No, there are some formats. For 136 special leave petition, there is a format. But it's not that you without format you can't do it. The format you will find from the court. Even if you go to court and you request the court staff that kindly give me some format, they will help you out. But it's not necessary that nobody will give you format. And even if nobody gives you format, see, I remember I have to draft a writ of habeas corpus and I have never filed it. So it was very difficult. And the client came at the last moment in Diwali. What did I do? I sat down with my juniors with laptop and desktop, and what did we try? We find out some old judgments of the recent as well as old, and some landmark judgments. We find out the prayers from it. We find out the some how to write the facts of the case, how to write the jurisdiction clause. Everything you will find out. And if you read, keep on reading the judgment, your language, vocabulary, as said by me in other two lectures, will also improve. So always remember that you start reading it. That is the easiest way to draft. Nobody is going to teach you drafting. Of course, you can learn. There are seniors who will, but then they are busy in their own cases. They may not be able to give you that much time. But if you read it and whatever, and be not be case specific. See, there is a possibility you may not get case for 1 or 2 years. In those kind of cases also, you can always go and find out judgments and read it. And whenever your case comes, suppose the habeas corpus case comes, go and try to find out the habeas corpus writ petitions from the Bombay High Court. If you are in Rajasthan, go to the Rajasthan High Court website. And if you are unable to go, try to go into library, any court library. You take a basic membership. They will allow you to sit in the library. And through that, you can learn the basic drafting. And one more thing, if you are working with some seniors, there is a possibility you have some time. So take their paper book with their permission, paper books or what we call briefs or files, and try to read opposite lawyers' submissions, papers, read completely filing. When I went to Supreme Court for my internship, after 12 years of my practice to become an advocate on record, I remember there were 500 to 600 files, and on each file I had a mark that I have read this. I used to read in the night, I used to read 3 files because I wanted to learn drafting of the Supreme Court. So that is the easiest way to learn the drafting. So there is no more secret to drafting than this. But if you read the judgments, subject related or without subject related, trust me, you will know. In family court, there is one practice of giving draft issues before the matter goes for evidence. Now, in such kind of matters, draft issues, many lawyers find it how to get it. Now, if you go to Bombay High Court website or family court writ petitions, you will find or family court appeals there, or you will find FCA that is called here in Maharashtra. You will find so many FCA where these issues are framed, draft issues are framed. So you can find out readily from there, and you can accordingly form your own case. So easiest thing I've shared today about the drafting. Now next is stages of the criminal trial. And before that, I will read one order which is also of criminal court, and I'm sharing this. From next time onwards, we can have one volunteer who can read these orders. So I will also get little bit breathing time. See, this is from the Jammu. Can you all see this? ललिता आप देख सकते हो? Okay. In the Court of Chief Judicial Magistrate Jammu, see this is from the Jammu High Court. See the date 23rd June 21. Now Darshan Lal Thapa is a petitioner. His age is also given. His address is given. Now just look at this. Versus UT. Now Union Territory ho gaya Jammu and Kashmir. Through police station Pir Mitha Jammu. Now in the matter of bail application. These are lawyers' name given, and also the investigation officer also present along the CD file. Now try to read this order. A video is alleged to have gone viral in social media in which petitioner is said to have made a hatred speech against communities, following which district administration, Jammu through additional deputy commissioner law and order, Jammu brought the same to the notice of SSP Jammu for necessary action under law. Thereafter, an FIR number so and so for offence under section 153 of IPC seems to have been registered with police station Pir Mitha Jammu after the communication of additional district magistrate Jammu was forwarded to respondent SHO. Now, meaning of SHO, station house officer by SSP Jammu. It is alleged in FIR that video containing hatred speech stood uploaded in social media and same become viral containing speech full of hatred and ill will against a particular community. Based on this set of facts, investigation ensued and petitioner was allegedly rounded up on 20th June 2021. Petitioner who has allegedly been rounded up in aforesaid FIR, मतलब उसको FIR में लिया गया, नाम दिया गया उसको, as aforesaid, seeks release on bail on the grounds inter alia that he is a peace-loving and law-abiding citizen of JNK, Jammu and Kashmir, that he is innocent and belongs to scheduled caste community and has not committed any offence, that petitioner has been arrested by the respondent police station, that he has good reputation in the society, that he is prepared to furnish bail and surety bond, that in the event of grant of bail, he shall abide by all the conditions that this court may impose upon him, etc., etc. Ultimately, a prayer for grant of bail has been made. Now see, all the grounds are given. Learned counsel for petitioner in support of his arguments rely on the following case laws. So case laws दिया है. There are 4 case laws he has referred. And if you see the case law number 1, this is of 95, case law number 2007, case number 3 is 2019, and 4th one 2008. See, the lawyer has worked really very hard. Learned APP filed objection to this application and opposed the same on grounds amongst other. APP is assistant public prosecutor, उसको सरकारी वकील के भी कहते हैं. That offence in which petitioner is involved is heinous, antisocial and non-bailable in nature. That investigation is at inception, मतलब beginning में है, मतलब शुरुआत ही हुई है inception का मतलब. And release of petitioner on bail at this stage would cause impediment and obstruction in the smooth conduct of investigation. See, impediment and obstruction, these are the words very important. ये legal vocabulary है. That is the reason I'm reading this order. That an offender like petitioner does not deserve leniency and is required to be dealt with iron hands. See the language used, by not showing any misplaced sympathy. Word used is misplaced sympathy on given facts of the case. That grant of the bail to petitioner at this stage will encourage many others to indulge in a similar activity, in similar activities, and that acts attributed to petitioner have far-reaching bearing on social at large, and petitioner therefore is a potential threat to the maintenance of law and order, etc., etc. Accordingly, rejection of this bill application has been solicited. ये public prosecutor ने argue किया है. I have heard learned counsel for petitioner, learned APP for UT, that is Union Territory, have also perused case diary. Video clip in question was also viewed and seen in order to gauge the alleged utterances made therein. Investigating officer present in the court has also presented detailed police report in terms of previous order be placed on record. Now, see, during the course of investigation conducted so far, it has come to fore that petitioner seems to have made a speech before audience comprising of representatives of different organizations, exhorting therein that a community, name of the state community is purposely withheld herein, lest its disclosure may not be prudent given the sensitivity of the issue involved. Herein after referred to as particular community, engineered partition of country so as to maintain its monopoly to rule the nation. That in order to distract attention from horrible act of partition, this particular community designed, ये सारा जो paragraph it is about, वो जो video clip है उसके बारे में बोला. It is not judge is saying. This particular community designed and brought about assassination of Mahatma Gandhi. That this particular community also plotted to portray assassin of Mahatma Gandhi as belonging to another religion till his name was actually announced by BBC, a broadcasting corporation of news, and in the interregnum of petitioner asserts in said video that many people belonging to particular religion. See, there are some words which I am also finding it very difficult. Then I have to also learn with you. But the judges use such good words, and this is a stylish English, or I would say flow ornamental English. Belonging to a particular religion were massacred as a reaction to killing of Mahatma Gandhi. ये partition के time की बात हो रही है. That because of the plot of this particular community, 1 lakh people belonging to particular religion were killed, and their properties worth crores and crores of rupees vandalized in India. This is about all partition. A petitioner also seems to be urging in the video in question that Jammu and Kashmir police picks up the youths, pushes them to the border and calls upon them to run over to another territory, and thereafter they are fired upon, and then fake claim of killing terrorists is projected, etc., etc. It requires no reiteration that while considering a bail application, now this is judge observation. Or what is he saying? A bail application. Factors like gravity of offenses involved in a case, nature of the evidence collected during investigation, nature of accusation against accused. देखो accusation क्या है? This is the word normally हम लोग use करते हैं कि allegation क्या है, accusation क्या है? The societal implication of the offenses involved in the case. कभी-कभी किसी चोर को इसलिए नहीं छोड़ा जाता कि वो हमेशा चोरी करता है. तो सोसाइटल इम्प्लीकेशन होता है. विष्णु हैज आस्क्ड इन वन ऑफ द लेक्चर, वन ऑफ आवर पार्टिसिपेंट, दैट जो 379 है उसमें भी अप्लाई होगा. तो मतलब जो इसका अरनिश कुमार वर्सेस स्टेट ऑफ बिहार में जो लॉ लेट डाउन किया है, विल इट अप्लाई to this cases also. So see, in these cases it will not apply because उसका societal implication of the offence involved in the case, the severity of punishment which the offencer alleged carry, and prima facie satisfaction by court in support of charge are needed to be heeded and considered. Espousing this principle as guideline, I propose to deal with lease in hand. देखिए मैंने बोला था एक बार कि I propose to deal with lease मतलब case in hand. तो मैं इस केस को ऐसे डील करूंगा. This is what the judge is saying. Prima facie speech alluded to petitioner in the video that has allegedly gone viral is undoubtedly not only too outrageous but also highly obnoxious and brazen display of the hate. ब्रेजन का मतलब होता है बेशर्मी से, मतलब बिना किसी पर्दे के, मतलब कुछ भी सोच समझ के नहीं किया हुआ कार्य. And ill will against the community that petitioner is time and again referring to in his speech. Petitioner, by virtue of his utterances as depicted in the video in question, seems to be incredibly determined to drive and create a wedge of hate and ill will amongst different communities by way of polarization. Polarization का मतलब हिंदी में होता है ध्रुवीकरण. मतलब it's polarizing, दो लोगों अलग अलग लोगों को अलग जगह पे छोड़ देना. तो इधर कास्टिज्म लाने का कोशिश हो रहा है. The degree and the extent of toxicity that petitioner has demonstrated in said speech has all and every propensity not only to stir up the emotions of targeted community but also promote and encourage disharmony, feelings of enmity and ill will between different communities, besides showing the particular community in bad taste and poor light. Society cannot afford to nurture grudges. See, the language is very good. Nurture grudges. नर्चर अभी हम लोग कैसे बच्चे को नर्चर किया जाता है प्यार से, पौधे को, प्लांट्स आर नर्चर, but see here the word used in this context, society cannot afford to nurture grudges and brazenly propagate hatred intersect different communities. As they say, freedom of speech comes with responsibility. Evidence collected thus for during investigation does not give even a prima facie whip that the petitioner displayed such responsibility. The context, the content, the impact of video in question therefore squarely attracts prima facie involvement of petitioner in commission of offence under section 153A of IPC. That the political thesis or historical truth, if it be so, cannot be so presented as to promote feeling of enmity, hatred or ill will between different communities, is a proposition settled long back by the Honorable Supreme Court in a decision reported in AIR 1980, Supreme Court 763. What is aforesaid apart, it also needs to be pointed out that the quantum of punishment that offence is punishable with is only one of the circumstances, not the sole factor to be considered while deciding a bail application. Further, the offence involved in the case in hand manifestly has far-reaching and pernicious, ये pernicious ये word भी बहुत यूज है, pernicious bearing on public at large, more particularly when various crucial aspects like the participation of the representative of the organization that allegedly participate in the alleged function and their role contrary to law, if any, are still stated to be under investigation by investigating agency. And in investigation thus is at initial stage. जो investigation agency होती है मतलब वो पुलिस होती है. The case law relied upon by learned counsel for petitioner has no application to the facts of the present case and judgments so cited by him thus are distinguishable. For all what is said herein above, this application has no merit at this stage and same is therefore to be dismissed. CD file written to investigation officer in the open court after perusal. Before parting with it, however, is clarified that observations made herein above are meant for disposal of this application alone, and this therefore shall not be considered a reflection of opinion on the merits of the case that be subjected to trial upon completion of investigation. Disposed of. See, this word is used, disposed of. मतलब ये खत्म हो गई. As such, to be consigned to records after due compilation. Chief Judicial Magistrate, Jammu. Now, if you have seen this order, while I was reading, the words, the language, and also the way it is written, you can always find if bail application का ingredients क्या होएगा. Now, if you read such kind of 10 bail orders, ये तो मैंने डिस्ट्रिक्ट कोर्ट जम्मू का पढ़ा है. इफ यू रीड सच 10 ऑर्डर्स ऑफ हाई कोर्ट और डिस्ट्रिक्ट कोर्ट्स का सम सी स्टेट्स आर हैविंग देयर अपलोडिंग, बट डिस्ट्रिक्ट कोर्ट्स ऑल दी टू माय नॉलेज पूरे कंट्री में हर जगह अपलोड नहीं हो रहा है. इफ इट इज नॉट अपलोडेड एटलीस्ट यू कैन गो टू हाई कोर्ट वेबसाइट. इफ हाई कोर्ट वेबसाइट इज नॉट अवेलेबल, ऐसा तो है नहीं, बट देयर इज अ पॉसिबिलिटी कि अंडर कंस्ट्रक्शन है, कुछ रीजंस है. देन ऑल्सो indianqanun.com एंड देयर आर मेनी अदर बार एंड बेंच भी है. They are giving some access to it, live law bhi hai. So there are so many things. Normally I refer to bar and bench and the indianqanun.com, which is my favorite. There is also SCC online. Uska kuch part hai which you can read without even investing money. तो आपको सब्सक्रिप्शन लेने की जरूरत नहीं है, because you are just students right now, and right now I will not even ask you to buy books also. It's better you take some library का कुछ भी ये लीजिए, किसी सीनियर को ज्वाइन कर लीजिए. So, and how to join senior also we will be discussing in the coming lectures tomorrow onwards. And today stages of criminal trial, we have a little less time, so I will keep 5 to 6 minutes for interaction and for vote of thanks. So we can have 4-5 questions, and when 2 minutes will be there, Vishnu will be giving the vote of thanks to my knowledge today. So thank you very much for patient hearing. Now I'm open for your questions. So come on, shoot. You can unmute yourself.
Ma'am, I have a question.
Yes, yes. आप वीडियो ऑन कर, it is very difficult कि मैं
Ma'am,
internship ले रहे हो and I can't see my own interns. आप वीडियो ऑन कर
ma'am,
दीजिए. Yes, who is speaking?
I'm asking.
Who is speaking?
Vandana.
हाँ बोले बोले.
If a lady is found guilty of murder of a husband and whose dead body was not recovered, so she was sentenced by court for 14 years imprisonment. And after completing her sentence, when she returned home, she found her husband with a woman. And by seeing this, she killed him. So whether now she can be punished for murder for the same offense?
Now this is like a movie, hypothetical situation है. So we don't have such case. But if this kind of case comes to me, she has already has been punished. Secondly, when she was punished for offense which never happened. And there was such kind of movie also in Hindi. I don't recollect the name, but there's a hypothetical situation. We don't know when it comes to it. Then only we can decide. But she will be again. There will be investigation. Of course, she can go to court for compensation for arresting her and punishing her for the offense which never took place. But now she has killed her husband, so she will be. The offense is offense anyway. She will be arrested and there will be a trial.
Thank you, ma'am.
Anyone having any more questions? Okay, then I'll end the session. Vishnu.
Soumya Pachori has a question.
Okay, okay. आपका वीडियो ऑन करके बोल दीजिए ना प्लीज.
Ma'am.
Yes, yes.
Ma'am, clause 3 of section 18 of the Hindu Adoption and Maintenance Act 1956 provides that unjust women cannot claim maintenance from her husband. So my question is, how we can prove the unchastity of a woman?
No, I didn't get you. What is the last line you said?
Ma'am, how we can prove the unchastity of a woman?
How would you prove? See, adultery is
Yes,
always committed behind the closed door, so you will never know. You have to bring the chain of circumstances. See, if every day some lady goes to hotel with somebody else, or see, there is a kind of proof. It may be WhatsApp, it may be emails, it may be photographs. There may not be photographs totally. They were in close relationship. But if a married woman, is seen again and again with somebody else without a reason. I had one case in a family court where I have produced a bill where the woman was talking continuously, or man, anybody. She was not working with him, that another person. But every night there was a call, at least of half an hour and more than an hour. So I can find out from there.
Okay, ma'am. Thank you.
Okay.
Anyone has any questions? Now we can end the session then.
Okay, sure.
I request Vishnu to give the vote of thanks to ma'am.
Thank you, ma'am, for your efforts and guidance on this third day of internship. You have very beautifully explained the topics RTI, PIL, drafting, and judgment reading. So I hope that your information, your guidance will help we all students in our future life. I must say thank you to Vandana ma'am for giving me this opportunity to express vote of thanks. And I also say thank you to all the participants for joining this session and making this event more successful. Thank you, everyone, once again.
Thank you. Thank you, everybody. I'll end this session. Thank you.
Thank you, ma'am.
Thank you.